Hello, listeners, and welcome to Privacy Chats with Rachel and John, podcast for privacy professionals and enthusiasts alike. I'm Rachel.
And I'm John, and we are your hosts.
Yeah, you said you wanted to talk about HIPAA today, John. What brought this on?
Yes, for the last couple of years, we've talked about this along the way. I've been working on a master's degree in legal studies with a concentration on cybersecurity and privacy law. So
yeah, which is like no small feat at all. So kudos to you, John. You're incredibly dedicated to your craft.
Well, thank you. I am in the final stretches of it, so I'm really excited to be finishing soon. I'll graduate next month. So I'm also, that brings up a good point, I'm looking for that next great role for me. So if any of our listeners have any good jobs in the privacy cybersecurity field for me, reach out to me on LinkedIn. You can find me there.
You'll be lucky to have John on your team, folks. Anywho, I'm sure that your master's course spent ample time on HIPAA, right? It's a big part of privacy law.
It is a big part of privacy law, and I feel like I referenced it a lot along the way. I did just wrap up a term, and the entire focus of the whole term was just HIPAA. So I spent a ton of time on it, and I figured since I could probably eke out an episode here that's just focused on HIPAA.
Nice. Yeah, thank God, because I mean, in my current role, I feel like HIPAA is not something I think about in the forefront, especially at a deeper technical level. So, we're really focused here with HIPAA on protecting individuals' health information, right? That's the whole gist of it.
It is. A part of HIPAA is about protecting health information. So it stands for the Health Insurance Portability and Accountability Act. So there is some boring stuff about health insurance in there, but there is a huge focus on protecting health information. The biggest misconception is that HIPAA protects all health information, but it doesn't.
Okay, so I was on the right path then, I guess. Partial credit for me. And I love to also talk about the fact that like HIPAA is not hippo with an A, it's like HIPAA. So another, pop quiz, or what do you call it? Trivia question that our listeners can get right, maybe. But what are HIPAA's limits?
Agreed. I've never seen it with an O, but people will often do it with two P's, HIPAA. Yeah. But so the limits. So this is something that I've thought is interesting for a long time. So sometimes you'll hear people talking about health related stuff, or they're talking about a person, and somebody will inevitably chime in and say that's a HIPAA violation, or you'll ask a question about somebody's health or something and say like, you can't ask me that, it's a HIPAA violation.
I have heard that before.
Right, but those are not HIPAA violations, and the reason is that HIPAA is narrowly focused on what inside the law it calls them covered entities and business associates. And just to keep it simple, covered entities are places like your doctor's office, the hospital, or any other medical provider. It also includes things like your health insurance company, and companies that they use to process insurance claims. There's also there's an interesting caveat to the definition of a covered entity that says, this is a quote I'm going to read: a healthcare provider who transmits any health information in electronic form in connection with a transaction covered by this subchapter.
Interesting. So the old-fashioned doctor's office that only uses paper filings, I imagine, would be off the hook then?
So it seems to me, according to this filing, this definition and the wording, but are there doctor's offices like that around still?
Yeah, I don't know. And you also mentioned business associates, and it sounds very formal. I'm picturing like someone with a clipboard and the suit and stuff standing right in front of me. I'm like, what's that about?
So the reality is that doctors' offices, they have to rely on services of other people and companies to operate. So examples are things like the companies that help them to schedule their appointments or send reminders, or the billing companies that send out invoices to patients for, whatever portion that your insurance didn't pay for. And so companies like that, they often need access to your health information just in order for them to do the work that they do. So these companies are not healthcare providers, but they shouldn't be off the hook for protecting your data.
And they are business associates then?
Yes. So that's pretty much the broad category for business associates. Yes.
Yeah. So what are the business associates standards like when compared to, say, like a doctor's office? Are they held to the same standards?
There are some differences, but we don't need to really get into those nuances. Overall, since they're processing your health information on behalf of the doctors or the covered entity, they are required to adhere to many of the same requirements. Um, and like, in the law, it'll say, in most cases, it'll say covered entities and business associates must. There are some places where it's a little bit different, but overall, they're pretty much the same.
They're like bucketed together in most statements. So what about somewhere like the nurse's office at a school, a public school, where kids go and they get Band-Aids or complain about stomach aches and get cartoon characters on their boo-boos and Band-Aids?
Yeah, that's an interesting one. So records contained or retained in by educational entities are generally protected by FERPA. We've probably mentioned that in the past before. It's the Family Educational Rights and Privacy Act, and it was
Yeah.
enacted way, way before HIPAA. I think it was from the early
Really?
1970s. Yeah. It's been around for a long time. But HIPAA, since it came second, it specifically excludes records that are stored in educational records that are covered by FERPA. Very specific, it's an exclusion. But there are some edge cases where HIPAA might apply, and again, that's getting deep into the weeds. But either way, people should feel assured that their records that are being retained by schools are generally protected by either FERPA or HIPAA. There is a significant exception that FERPA specifically applies to schools that receive federal funding. So there are, a lot of schools, like private schools out there, that don't receive federal funding. So
Yeah.
they really don't fall under the scope of FERPA.
Oh, I didn't know that either. But okay, going back to HIPAA's coverage, what about like
Yeah.
medical device suppliers, manufacturers, people that make the tools?
Yeah, it kind of depends for those. So HIPAA defines healthcare. So this is how it defines healthcare, the term, as care, services, or supplies related to the care of an individual. So that's a very significant word, of an individual. So I'll pick Johnson and Johnson, for example. They make a bunch of medical type stuff. So when they're making Band-Aids, perfect, yeah, the Band-Aids. I guess in the schools, like they often have little cartoon characters on them, like SpongeBob or something. But so we could say that Band-Aids are medical supplies, but when Johnson and Johnson makes them, they're not making them for a specific individual. They're just making them for their consumer market. They're going to be in your pharmacy or your grocery store. They don't need to know who the specific individuals are who are using them, or like what medical condition they have that requires them to have a Band-Aid. But separate from that, if you order a wheelchair or like, I don't know, a medical bed or something for your elderly grandmother, the company that's going to be providing that, it's really a service at that point, or supplying the devices related to that care, they are going to have her name, and they're likely going to have her insurance information to pay for it. And inside of that, that's probably going to have information about her diagnosis. So that's going to describe her medical condition. So in that case, they would be subject to HIPAA because they're providing health services that are related to an individual, whereas Johnson and Johnson making Band-Aids are not.
Yeah. It's when there's the element of like individual identification and specific information to that unique individual, it sounds like, right?
Yes, it's because it's for an individual. And I think let's keep going, because I think
Get
we're
into
gonna
that a
talk
little
about
further
that.
for sure.
Yeah.
I guess that brings me to the scope of data that should be protected or needs to be protected by HIPAA.
Yeah, so it's a great question. The most significant part of HIPAA from our perspective as privacy and security people it's called Part 164, and there's one subpart C, and it's titled Security Standards for the Protection of Electronic Protected Health Information. That's often called the security rule, and then a little farther down in the law is subpart E, which is called the privacy of individually identifiable health information, which is commonly called the privacy rule. So there's a security rule and a privacy rule. The privacy rule starts with, so there's some definitions in that section of the law, and then it really starts with and says a covered entity or business associate, like I said earlier, may not use or disclose protected health information except as permitted or required. So it's very specific about protected health information.
Yeah. So I kind of like, though, you were talking about the subparts, that it's commonly called the security and privacy rules, respectively. I've heard
Yeah.
that before, so I guess we'll hang on to it to others that have heard that. But what is protected health information? Talking about definitions a little bit more.
Yeah, I don't want to go too deep into this, but HIPAA has a couple of definitions that it gets really specific. But the first one is they define health information. So, and well, obviously, well, you have to define that, but they do. So, and it's very specifically that that's information that is created or received by the healthcare provider and other places like that. But it also relates to the past, present, or future physical or mental health or condition of an individual, the provision of care to the individual, or the past, present, or future payment for the provision of health care to an individual. So it's really talking about it's created by or received by the provider, and it's about health conditions. Separate from that, there's a different definition for what they call individually identifiable health information. And it's kind of the same. It's created by the provider. It relates to some health condition. But then it has to very specifically identify the individual, or that there's a reasonable basis to believe that the information can be used to identify the person. So it's health information that's tied to a person. And then the last one, which really gets kind of interesting, is protected health information is really identifiable health information. And then it has very specific things that says that it's transmitted by electronic media or maintained in electronic media or transmitted or maintained in any other form or media.
Very specific. There's no, I mean, I guess from a layman's perspective, like it's still sounding a little ambiguous, and like these definitions are overlapping each other and are even like bizarre at times. I guess like why is it not simpler? Why isn't it like just three different lines? Like this is that and the other and done.
I really don't know. I suspect it goes back to the origins and the name and the law, the health insurance portability.
Yeah.
So it's focusing on the mediums through which health insurance information might be transmitted or maintained. Like that's really
Yeah.
what the original focus was.
It's it is perhaps a mirror of, the intricacies and the complexities of how health information is shared in general, not even necessarily protecting it or securing it. So,
Right.
okay, we'll get back to the scope though. What needs to be protected, I guess, if you can give any examples, that'd be great.
Yeah, the scope is pretty broad. So the example that I want to use here is sign-in sheet. So you walk into your doctor's office, you go up to the front desk, the person's usually on the phone when you get there. And you when you sign in, when you get to the doctor's office.
Yeah, the sheets with the little strips that you peel off after you sign in, right? That has to be related.
It is. So clearly the intent is to prevent other patients from coming behind you from seeing who signed in before them. Right?
So yeah, and you think that's necessary, right?
I think that it is. So the sign-in sheet, it's information that's clearly is collected by a provider. So we talked about that in the definition. And while you could argue that it doesn't contain any health information, let's look back at one of the definitions. I don't know if this is the one I read, but it is. It relates to the past, present, or future physical or mental health or condition of an individual, semicolon, the provision of healthcare to an individual, or past, present, or future stuff. So by signing in at the doctor's office, you are seeking the provision of healthcare. So even your name on a sheet is in scope.
Wow. I mean, very, very, I guess, nuanced, specific, but I guess necessary because I know, like, I can imagine my information would be super interesting, but what if, you're a nurse caring for like a celebrity, or what if they're like,
Yeah.
doing paperwork in front. I don't know. Like there's probably some interest to some individuals, and that can extend all the way down to what you're there for.
There could be, but even if you were to look at like the type of doctor, like you can't look at somebody's name on a sign-in sheet and know something about their health condition, except that if you're at a clinic that treats STDs and that's all they do, and
True.
you see somebody's name on the list, well, and you can make the assumption that they're there seeking care, and they obviously must have an STD if
Yeah.
they're at this clinic seeking care. So that's, could be embarrassing for them. So,
Yeah. So
it's
the
a
sign-in
good
sheet is like a
example.
low risk example of other instances that are perhaps higher risk, but it falls in that same category for that reason. It's, you know, related to health conditions and it's managed by the healthcare professionals around you. Got it.
Yeah. Yeah.
Are there any other exceptions or exclusions that are like this, or I guess not like this?
Right. There is actually quite a few exceptions. I have some examples, but in the act itself, these are spelled out in far more detail with lots of nuances and conditions and stuff like that. So I'm going to breeze through 4 or 5 of these. So there's disclosures for whistleblowers. There's disclosures that are exemptions and exclusions by workforce members who are victims of a crime,
Mhm.
under certain circumstances for law enforcement. There's disclosures with protections for public health, which I used to work in a school for public health.
Yeah.
So I'm very familiar with that. Disclosures related to abuse, neglect, or domestic violence is another example.
Yeah. There's those all make sense, and some of them are even familiar from some of the exclusions we've talked about before. I mean, like law enforcement, for example, is a pretty broad and common one. But I guess, what are there circumstances for law enforcement in this case to get involved? Like, have you read up on those?
So there's a couple of nuances in this area. The first one I think is notable. It's a section related to what's called disclosures about victims of abuse, neglect, or domestic violence. And the regulation requires that a covered entity may disclose protected health information about an individual who they reasonably believe to be a victim of abuse, neglect, or domestic violence to, and it talks about the places that they can disclose that to.
Mhm. And presumably this ensures that the healthcare providers are able to get help for the people who are victims of abuse.
Yes, and I think that that's very important.
Mhm.
As a society, we should ensure that there are many, many ways to help victims of abuse, neglect, or domestic violence. But they should just be able to get help.
Yeah, I couldn't agree more. I mean, the data protection is wholly important, but so is the integrity of our social contract, right? Like helping people in need and providing the means of justice when they need it.
Yeah. But so even with that, the regulation still offers protection for the subjects of the data, like the victims in this case.
Mhm.
So it requires that either the person who the data is the subject of the data, that they consent to the disclosure, or it says, and I'm going to read it. It says that the covered entity in the exercise of professional judgment believes the disclosure is necessary to prevent serious harm to the individual or other potential victims, or if the individual is unable to agree because of incapacity, a law enforcement or other public official, if they represents that the protected health information is not intended to be used against the individual. So
Mhm.
I think that's
Yeah,
key.
helping, not hurting, right? So the permission
Right.
to disclose, even for those cases of abuse and neglect is not a wide open door here.
Correct. And I really like that the language in this section includes allowing both doctors and law enforcement professionals to educate or to exercise their own professional judgment about what to do in these situations.
Yeah, I agree. You need to let doctors and experts do their thing. You said that there was a couple of nuances here, though, but what else outside of this?
So the overall section about disclosures to law enforcement falls under a section about uses and disclosures for which an authorization or opportunity to agree or object is not required.
Very broad again.
It is, and it seems to start that way, but once you dive into it, it gets more specific. And by the way, that section that we talked about abuse and neglect, it's also part of that same section. That's seems pretty broad.
Yeah. So what are those limits on like law enforcement in those cases then?
So for law enforcement, the regulation lists 6 conditions under which disclosures may occur. So I'll kind of go through those. The first one is as required by law. And this includes things like there's certain jurisdictions, actually a lot of jurisdictions around the country that require hospitals to tell the police when people show up with gunshot wounds, for example. Or, if the disclosure is ordered by a court.
Yeah, those make sense.
They do. They do. The second one allows for disclosure for the purpose of identifying or locating a suspect, fugitive, material witness, or a missing person. The third one is law enforcement officials' request for such information about an individual who is suspected to be a victim of a crime. So we're looking for victims, but this again has other protections in it. So the first one is if the person agrees. So if you are the victim of a crime, you still have to agree. But if you can't agree because you've been shot, for example,
Yeah.
The cop can say that they need the information to investigate someone else, not investigate you, the perpetrator, and that the data that they're looking for isn't going to be used against the victim. And that the investigation would be materially or adversely affected by waiting for the victim to wake up, for example. And this one's my favorite one. The disclosure is in the best interest of the individual as determined by the covered entity in the exercise of their professional judgment. So, I like that. Again, we're relying on these professionals.
Having it with real world scenarios that might happen that would, prevent the bigger picture, i.e. stopping criminal from happening in light of, again, protecting data is important, but
and that particular one, and in that particular one, they're trying to protect the victims of
protecting people.
Yeah. The fourth one is very specifically is someone has died and the covered entity or the doctor's office or the hospital has a suspicion that the death might have been a result of criminal contact. The fifth one, I think, is very oddly specific. And it says, I'm going to read it verbatim. It says that they may disclose to law enforcement official protected health information that the covered entity believes in good faith constitutes evidence of criminal conduct that occurred on the premises of the covered entity.
Okay, so that one's not really specific. I feel like that's been kind of reverse engineered in a scenario that's happened at least a couple times before. And like we're getting into the details here. It sounds more like true crime, like podcast reading, but I don't know how we always end up going there. I imagine that, that last one, the really specific one, was related maybe to some guy like getting stabbed in a waiting room and they're like hiding a knife at their butt or something. And they're like, go take an X-ray.
Right. Maybe. I mean, yeah, if you're hiding knives in yourself, maybe you deserve to be caught, perhaps.
Really crazy example I brought up, but I don't know. Like, how is that all, or is there a number 6?
There's one. So there's one more. Number 6 is related to reporting crimes in emergencies, and it says that covered entities or doctor's office, they may disclose if the disclosure appears necessary to alert law enforcement to either the commission and nature of a crime, the location of the crime, or the victims of the crime, and the identity, description, and location of the perpetrator of the crime. So it's very specific. So that's the last one, is in emergencies, but for that very specific reason.
Yeah, that sounds, again, reasonable. Any other elements of HIPAA that just jump out at you that, layman, even privacy professionals not in the field like myself, like of health specifically, might be interested to hear?
Sure. There's a section about, it's titled "The Right of an Individual to Request Restrictions of Uses and Disclosures."
Okay. It sounds like a reasonable right to have.
It does. But just because there's a right to request restrictions, which is how it's worded, in the law, the covered entity doesn't always have to honor the request.
Okay, so you can request greater protection of your information or restriction of actually accessing it if a covered entity has it, but they're not obliged, the covered entity is not to follow that. So what circumstances can they choose not to honor those requests then, the covered covered entities.
Yes, strangely, I think in that section it just says that they don't have to honor it, but it doesn't say it give the reasons that they would have to provide for it.
Mhm.
It only says that except as provided in paragraph A1 Roman numeral VI of this section, a covered entity is not required to agree to a restriction. Oh, wait, except as so, yeah, so they're not required to agree to the restriction, but it says that if they agree to the restriction, they can disclose the information if it is needed to treat for an emergency. So you can ask them, don't share this, and they agree to that, but they can then share it if there's an emergency, like if you need to be treated for some reason.
Yeah, if I need emergency heart surgery, but I'm sensitive, really sensitive about my information, like you balance the risk of me
Right.
not making it with, I have to disclose my health information to understand how to perform surgery on me, right? That
Right.
emergency exception is like super reasonable. And I'm curious, in that other paragraph that you said, except provided in, like there's another stipulation outside of emergencies, maybe?
Yeah, it was interesting, and I actually had an assignment in my class that was, related to that very specific section. So it says that a covered entity must agree to the request of an individual to restrict disclosure of protected health information about the individual to a health plan if the disclosure is for the purpose of carrying out payment and the protected health information pertains solely to a healthcare item or service for what the individual or the person is about has paid the covered entity in full.
So if I'm paying cash for the treatment, this is what I'm getting from it. The provider must agree to not disclose the treatment information to my health insurance company because I paid.
Yeah, exactly. If you don't want your insurer to know something about you, like some health condition, just pay for the treatment yourself. But don't forget that you have to ask the doctor not to spill the beans on you.
Yeah.
And you might even have to specify that you're exercising a right that's codified in HIPAA.
I can't think of examples where, and maybe this is just my position where I might need to leverage that, but still an interesting tidbit, something
Well,
we're
it
learning on
is. And
privacy
I
chats.
mean, I was trying to think of examples. And let's say, for example, if you have a health condition that you think that if your insurance company knew about it, they might drop you. Is that even a thing? But
Yeah, I wonder.
yeah. So, I could see, yeah, I don't have any specific examples for myself or my family, but I could see situations where you might not want your insurance company to know about
Yeah,
things.
maybe it just goes to the purpose like limitation principle. Like if the insurance company needs to know because it's part of, they're part of the business transaction of providing your, funds for a certain health treatment plan, but
Yeah.
you're actually providing the money. Like it's like a need to know
Yeah.
basis thing. Why does insurance company need to care? Other covered entities that aren't otherwise involved, but that's who I see reading between the lines.
Sure. Um, so the yeah, let's start to wrap things up a little bit here. I mean, I could talk about this for hours, but in the interest of time and not, I don't want to be all Joe Rogan and go do a 3 hour episode
3 hour
here.
episodes are crazy.
Um,
Yeah.
yeah, I love Joe Rogan, but yeah, too long. But I think that what people should take away is that HIPAA it's a fairly decent protection of their health information within the healthcare community. Um, but in addition to rules about how health information may be used or disclosed, we also talked about the security rule that requires providers to protect against reasonably anticipated threats or hazards to the security or integrity of your health information.
What sort of protection then, or I guess what threats or hazards?
Yeah, well, I guess reasonably anticipating the threats and hazards. The law about what protections is intentionally vague, but the reason actually makes perfect sense. And if you think about it, there's like in the scope of all of these health providers and companies, a small town independent doctor's office somewhere in the plains of the Midwest, they're not going to have the same cybersecurity resources and abilities and capabilities as a huge corporation like United Health Group, for example.
Yeah, you know, expected fact, right? So how is that handled in the law?
The language specifically says that covered entities and business associates may use any security measures that allow the covered entity or business associate to reasonably and appropriately implement the standards and implementation specifications. That's getting into what it is. But, for example, it says that when they're deciding what measures to use, they can use different factors for determining those. And those include things like the size, complexities, and capabilities of their organization, their technical infrastructure and their hardware, the security software capabilities,
Mhm.
um, the cost of security measures, and the probability and criticality of potential risks to the health information.
Yeah, I mean, it's essentially applying a risk-based approach through the law and offering flexibility based on size and complexity and resources of the organization.
Yeah, exactly.
How about the scenario where providers, again, I get it's risk-based, but what if we just ignore all risks and, it's these need for protections were just wholly ignored? What are the penalties for that?
So the penalties are it's a tiered structure. So the lower civil penalties or fines are for what they call inadvertent or unknowing violations. Um, there's smaller penalties. There's much greater fines for what they call willful neglect, or particularly willful neglect that goes uncorrected. So we told you to fix that, you still didn't. Um, and the fines are calculated per violation for each record that's impacted, so it can get quite large.
Yeah, and that's good to know. But according to recent news reports, some of these big health insurance providers are making like crap ton of money. Like, can't they just pay the fines and consider it just a part of the cost of doing business, just being like a little nihilist here?
They probably could, but there's also criminal penalties, and those go up
Mm,
to as high as 10 years in prison. And the way it's worded in there is if the wrongful conduct involves the intent to sell, transfer, or use
mm.
health information for commercial advantage, personal gain, or malicious harm.
So it's addressing not just the willful ignorance of not having protections in place, but then increasing the risk posture of individuals who have healthcare information stored and managed by entities from basically being data brokers of that information. It's saying that that's an absolutely no-no, and that's, jail time worthy.
Jail time.
And I
Yeah.
can't imagine like the big corporate bigwigs like wanting to risk that. So I presume that's honored.
Agreed. I don't think they don't want to go to jail.
Does that mean, I mean, as far as my rights and perhaps obligations, if my doctor's office violates my privacy under HIPAA, perhaps they want to go be a data broker now. Can I sue them?
You cannot. HIPAA does not include what's called in the law private right of action.
Mhm.
The authority to enforce the law is given to the Department of Health and Human Services for civil penalties and to the Department of Justice for criminal penalties.
Normally, I would be like kind of thankful for that because there would be resources in place to help me do, things like implying enforcement action that I'm not as a citizen really positioned to do well. But I mean, we're seeing all of these federal departments being gutted right now by Elon Musk and his merry band of kitty friends. And, but I question, and again, it was the theme of the last podcast. It'll be the theme for future ones, at least as far as my
Yeah.
research is concerned. Like where does that put us as far as, our current standards? And should we see those slip and fall because we're going to have less support to enforce them?
I think that the entire regulatory environment is weakened right now.
Mm,
So yes, that's a problem. But that doesn't change that law. You can't. There is no private right of action under that law. If you think that there was a violation of HIPAA, I would say you should still report it. I mean, the reporting structure is that you would either go to your state attorney general or directly to HHS and, go online. You can fill out a form for them. And even if
yeah.
they can't take action right now because everyone got fired or they're focused on other things,
No one's getting
um,
paid. Yeah.
yeah, exactly. But those files are still going to be there, and action can be taken in the future when the government gets its shit together. So
Yeah. And I mean, historically, then do they take enforcement actions pretty seriously?
They do, at least they have in the past, and even up until recently. I found an article in the January version of the HIPAA journal,
Mhm.
and it reported that, and this is a quote, across the 22 enforcement actions, the OCR, the part of the government that does this, collected more than $9.9 million in fines, with an average penalty of $514,000 in 2024. And then it said the biggest penalty was imposed on, I don't know if I'm going to say this right. It was called Montefiore, Montefiore,
Sounds right.
medical center. And that was a seven or $4.75 million fine, to resolve what is called multiple HIPAA security rule violations.
Yeah, it is comforting to hear then. At least historically, there's been some teeth to the law, and the entities
Yeah.
are incentivized to take it seriously.
Agreed. And for the most part, I think that we should give credit to our healthcare providers and the entire health industry, not
Yeah,
just for what they do in caring for our health, but they also seem to be taking privacy seriously, and they do their part to honor, I think, both the letter of the law and the spirit of the law. I think that they're doing their part.
agreed. Kudos to them for sure. And with that sentiment, I think we can bucket this one up, right? Thanks for doing the research on this. You really drove the whole start to finish of what's HIPAA, what does it cover, what doesn't, who's involved, how are they involved. So thank you.
Sure, you're welcome. I'm glad to do it. It was fun doing the research on that one.
Yeah. Before we go, I have one last disclaimer. Please know that the information shared throughout this episode is that of our own and not in any way affiliated with our employers or other organizations. These episodes are produced on our own time and are based on our own research and professional opinions. It's a wrap.
That's a wrap. Thanks, Rachel, and thanks everyone for listening. See you next time.
Yep. See you next time.